SJC-12061, Commonwealth v. Brian M. Grassie.
Mr. Anderson, still good morning.
Good morning, Your Honor. Kenneth Anderson here for Brian Grassie. Although I believe we're here today because of the Walls Act decision as that impacts this case, which is why we're here today in front of you instead of in the appeals court last March as scheduled. I'd like to begin my presentation by focusing on why we suggest the trial judge, qualified though he is to sit on this court, erred in not granting a required finding of not guilty, and so much of the indictment is alleged second-degree murder, and how he erred or abused his discretion in not granting the Rule 25 motion, and so much of the indictment alleged second-degree murder. This is a tragic case when viewed from every single angle there was. And although we don't agree that there was sufficient evidence for the jury to find second-degree murder, before this court, I suggest it doesn't matter, because this court has held that even in cases where the evidence does support the jury's verdict, that there is the ability to reduce a verdict if it's substantial with substantial justice. And that's what I suggest we have here.
So, I'm sorry, I thought you said you were going to argue both required finding and the 25B2, but that really goes to 25B2, doesn't it, what you just said?
Well, I think in the 25B2, that's where the court can look at it under your, kind of under the 278-33E standard. But I think in both situations, the facts really didn't warrant a second-degree murder conviction, and that it should have been taken away from the jury before it was submitted, and that on the Rule 25 motion filed after the verdict, that it should have been reduced to manslaughter. This is a tragic case involving a drunk, intoxicated, skinny, 18-year-old male on blood thinner medication who goes to a graduation party where he wasn't invited. It was clear that there was too much alcohol at this party, and it's clear that there was no parental supervision whatsoever. And in this fact pattern, it's clear that my client acted like a jerk. He was confrontational to people, he mimicked people, he got in people's faces, and he tried to pick fights with people. But at the end of this party, when he was leaving, it's clear that he had not laid a finger on anybody. He had had a cigarette thrown in his face by Brendan Mahoney. And he had Brian Mahoney reach over, put his hand on his face, and push his face away.
Is this still in the house?
This is in the house, correct. He goes outside of the house. The host of the party, Dylan Burns, ultimately convinces my client to leave. He's walking down the street. Granted, he's calling the group faggots and pussies and challenging them to fight.
At least Mr. Thompson says that he's walking backwards, or there's evidence that he's walking backwards, screaming at the group behind him. Is there evidence to that?
Yeah, I believe he was facing the house as he was walking away, but this party happened at 29 Priscilla Avenue. It's clear that he walks past house number 13, which is the house with the camera. He goes up over a hill, past a street light, and he's beyond house number 13. So he's gone from 29 to 13, and he's gone from the party in that situation. And at that point, according to Dylan Burns, the host of the party, the group collectively says, let's go get him. And the two Mahoney brothers go, followed by two others, and then Dylan Burns, and then three more. And
Also, Mr. Thompson says at some point he's like waiting for them. Is there evidence of that?
there was evidence of that. There was also evidence to the contrary. There was a witness who testified that he ran away from the scene as they approached. There was testimony that he remained in the shadows beyond the streetlight. But it's clear he didn't come back and engage the confrontation there. He stayed being chased by 8 people. And in this context, it was a fight at least 2-on-1 in my client's mind. And it certainly could have been 3-on-1 or 4-on-1, 5-on-1, 6-on-1, 7-on-1, 8-on-1.
So just that waiting part. So he's in the shadows and they come upon him? Is that what the evidence is?
The evidence is that
Come out at them when they get to where the shadows are.
it wasn't fully clear from the evidence, but he's gone, he's walking, he's left the party. According to Officer Aronson, who was one of the responding officers, he encounters the Mahoney brothers after the situation. They hadn't made it all the way back to the house, I believe. And he testified it was 50 or 60 yards from where he met the Mahoney brothers to where this incident occurred. So they're at least a half a football field away. And this isn't going to be an altercation that's fought by the Marquis of Queensberry rules where it's going to be a fair fight. It's clearly going to be 2-on-1, 3-on-1, 4-on-1. And I suggest to the court in this situation, with the sudden provocation, that my client was clearly entitled to use deadly force.
Can you tell me whether or not, what the evidence was, what the evidence was on your client's state of mind about the Coumadin? I didn't read the transcript, but did he testify to what he was thinking because of the medication that he was on? How did that come in to the case? Was it just medical records, or was it his testimony?
He did not testify at the trial.
Okay.
He had told one of the individuals at the party that he was at blunt-thinning medication, and then his father testified as a witness for the Commonwealth and testified that he was on Coumadin, blood-thinning medication.
Okay, so where was the connection between the medication and his state of mind about what he needed to do once he was attacked by these people?
Well, it wasn't presented there, but I suggest it's a rational inference that if you're on blood-thinning medication that's going to prompt you to bleed more than a normal person who's not on blood-thinning medication, that you engage in that altercation, you're putting yourself at greater risk. And I did a quick little Westlaw search this weekend, just looking for cases that have come before this court or the appeals court, where people were beaten to death with hands and feet. And there were several cases that just came up very quickly. I mean, there's a case of Commonwealth versus Junta, the case that I'm sure you're all aware of, where the fight at the hockey rink, where 270-pound individual fought a 160-pound individual and beat him to death with his hands. There was a case, Commonwealth versus Senate, which is 399 Mass 863, where a victim by the name of Tamboro punched an individual named Masso. And then Masso got on top of him and pinned his head and his arm with his knees. And according to the testimony, he gave him 6 shots with the elbow to the head, what was described as being like a ramrod. Tamboro goes to get up, Senate comes over, kicks him in the face, and then they kick him to death, essentially. And there's another case, Commonwealth versus Mahoney, 406 Mass 843, where it's described as kind of a 3-on-1 barroom brawl in an apartment in Lowell with hands and fists. So in this situation where there's a sudden combat, it was clear that my client was punched, was knocked into a fence, was kicked at, and then he had 2 individuals jump on top of him and 6 others running down the street, that he would have been justified in using deadly force.
So is there any dispute in the evidence as to who struck the first blow?
There was no dispute about that. It was not my client. It was Brendan Mahoney struck the first blow.
Now, have you seen our Vargas opinion recently?
Which case?
Commonwealth versus Vargas.
Last week?
I guess not. But the question is, if he had been convicted of first-degree murder, we would have the ability under 33E to say, if we thought it, as we did in Vargas, that a manslaughter conviction is more consonant with justice. We don't have that authority under 33E pursuant to murder 2, unless you think we do. I mean, do we have the authority to say this is more consonant with justice, and the fact that it's a murder 2 conviction as opposed to a murder 1 conviction doesn't change that, or are we limited to find that the evidence was insufficient as a matter of law, or that the judge abused his discretion?
I can't address whether 33E would apply in this situation. I can't. But clearly where the Superior Court judge who tried the case has the ability to take those 33E factors and look to see if the judgment was not consistent with substantial justice, I don't see why you would not have that ability. And
Mr. Thompson says we have never reversed a judgment on a 25B2 of a trial judge. Should we be thinking about that?
Well, again, I just think whether you have or you haven't, in this situation, I think the evidence really kind of screams out for it. I mean, this is a 18-year-old kid. It's a tragic situation. It's very much like a case cited in my brief, Commonwealth versus Keogh, where there was a road rage incident. 2 cars, one car has 4 individuals, one has 2, and they kind of go back and forth, and they ultimately pull into the same school parking lot. And the driver of the one car that had just him and the passenger goes up to the other car, confronts 3 people, gets in an altercation, and one person from the car with 3 comes back and comes up to the passenger in that second car, and as this passenger's trying to get out, he's grabbed by the neck and he stabs the person once in the heart. And in that case, the Superior Court judge found that manslaughter was more consistent with the facts of that case, and in so stating, he said, "This is a tragic case in which a minor controversy between strangers exploded into the killing of a human being. A number of significant facts are undisputed. The judgment of the persons involved appear to have been affected by the consumption of alcohol. The defendant and the victim had no previous confrontation. The defendant had the murder weapon in his possession. He did not leave to obtain it and return to confront the victim. At the crucial moment, the victim sought out the defendant for confrontation. There were 4 persons in the victim's group and only 2 in the defendant's. The entire incident was characterized by senseless conduct by both groups. There was no evidence of the defendant's prior criminality."
So that sounds perfectly reasonable, and it wouldn't have been unreasonable in this case. But that's not what the trial court judge did. Now, moving away for just one moment from 25B2 and going to the required finding where we take the facts in the light most favorable to the Commonwealth, isn't there evidence that your client said that he was going to wait for them or meet them somewhere?
There was evidence that he said he was going to meet them down at the beach, and the beach was in the direction he was going. But again, he'd gone. I mean, he's 50, 60, 80 yards down the street. I mean, he's left, and there's been no confrontation.
He said he was going to wait for them, though, right? In the light
Right,
most favorable to
but we don't
Commonwealth?
know if he was going to or not, because had this other group decided not to pursue him, this whole episode never would have happened.
But he invited them to pursue him, didn't he? I mean, he said, come, and he waited, and he had a knife.
He did, and then he clearly realized that he had bitten off way more than he could chew, and, you know, he was, at that point, he's confronted, he's on the ground, there's 2 people assaulting him, and I think at that point, to defend himself from
Right.
death or serious bodily injury, he...
But how can it be considered sudden combat if he initiated it? I mean, not the, I understand he didn't initiate the physical part, but he invited it.
But I suggest to you that words aren't enough to constitute initiating that conduct. And again, he's 50, 60, 80 yards down the street. So I would ask you to, in light of that, to consider making this a manslaughter case, reduce the verdict to manslaughter.
But what do we do, and again, I've not looked at the record of the case, for somebody who says, come on, hit me, inviting somebody to hit them, and then when they do, has the knife ready to stab them?
Well, again, I don't think that words are adequate provocation. Again, there's a time distance, there's a distance separating these individuals, and there's no evidence that the knife was actually ready at the time of the assault. I think the evidence is that he had both hands out with no knife in it, and the knife didn't come out until after he was assaulted.
And was it a switchblade, or was it?
It was a folding knife.
And so he would have had to unfold it.
I'm not 100% certain of that. I do not believe it was a switchblade, but just if you look at the number of stab wounds here, it was, 5 stab wounds and 1 cut, with the exception of the one to the stomach of Brendan Mahoney, who, unfortunately didn't pull through this incident. They were all in the lower legs. They were all in the buttocks. I mean, they were all in an upward defensive motion. So, having said that, I'll move on to the Walzak issue. I would just ask this court to adopt the rule that was proposed by Justice Gans.
What do you say on that, if we do, all the sort of practical questions that the Attorney General and the Commonwealth raise here? What do you say about, implementation issues?
Well, I mean, I don't think there's been a lot of implementation issues of Walzak in and of itself.
Well, I'm not sure there've been that many indictments for,
But I don't think, I think the evidence in the case is that it was a scant burden on the Commonwealth to instruct the grand jurors on mitigating circumstances and what their significance is. I don't think that the sky is falling, as the Attorney General's office tries to portray it in their amicus brief. There are issues, but certainly I think those are issues that can be dealt with by the court.
And if we,
Ask you, the preface in Walzak was that the instruction would be required if there was some risk that the function of the grand jury would be undermined by the exclusion of the evidence. I mean, do you have facts in this case that were comparable to the facts in Walzak that would trigger the Walzak rule, even if the court were to agree to apply it to adults?
Well, I think that the facts of this case are actually stronger in terms of mitigation than Walzak. In Walzak, it was an issue about the evidence itself being presented. It was a lack of instruction, and I think the word used by Chief Justice Gantz is that it would be meaningless not to.
It's not instruct in every case. I thought it was that the obligation would occur in certain circumstances where there was this risk that the function of the grand jury would be undermined, that they would come to a different decision if the evidence were withheld. I mean, you're having a hard time showing the insufficiency of the evidence in this case, and that kind of bleeds into whether or not there would be facts that would be required mitigating facts that would be required to be revealed to the grand jury in this case.
No, it wasn't an issue of facts being presented to the grand jury, because in this case, the Commonwealth called pretty much every witness who was there and questioned them about everything. So all the exculpatory evidence, all the evidence of mitigation, that was all presented to the grand jury.
Okay.
But
So your problem is that there was no instruction. What would be the advantage to that in this case? I assume that the instruction is to help. The instruction about the elements is to help the jury understand the mitigating facts, right?
correct. And the grand
Okay.
jurors are never told about the law as it applies to these mitigating circumstances. So the evidence was presented, but again, as Justice Gant said, it's meaningless because they don't have the legal framework to put those facts into. And in this case, there was substantial evidence of mitigation, of sudden combat, of intoxication, of excessive force and self-defense. But the grand jurors were never instructed on that. So they didn't know how to use that evidence. And
Let
in
me
my,
do we know whether or not the grand jury was instructed on the elements of the crimes?
it's my understanding that at the outset, when the grand jury began to sit, they were instructed on all of the elements of the crimes. And that's,
By whom? By the DA?
I believe it was by the,
But
We know
that's-
that, I mean-
don't you mean the grand jury, like on day one of
Correct.
hearing? This is what murder is, not in the context of a particular presentation of evidence to secure an indictment.
correct. If it was the grand jury that was sitting January, February, March, on January 2nd or 3rd, they would
They
have,
would have heard instructions on all possible crimes that the grand jury might have had the request to indict?
I'm sorry, I didn't,
I wanted to know whether or not, we know whether or not this grand jury was instructed on the elements of the crimes here.
they were at the outset of the sitting of the grand jury, not in any specific relationship to the presentation of this case.
And we know
Just-
that because we have a transcript, or how do we know
There
this?
was a stipulation entered into in the Superior Court, and that was presented in the motion. And as just suggested, everything was done to preserve this Walzak issue throughout the process, pre-trial, 211-3 petition that was denied, and every effort was made to.
And if we were to adopt Walzak, why would we not make it prospective? This case, of course, was decided before, not decided, the indictment was brought even before the Walzak opinion issued. They would have had no reason to know about that, and it has not been the custom. So why would we not make it prospective?
Well, it's my understanding in the law that the retroactiveness applies based on the judgment, and the judgment in this case came 2 years after the Walzak.
But remember, in Walzak, the Judge Feely, had dismissed the indictment. There had been no trial in Walzak, so the issue, the case had not been tried, and the question was whether to affirm his dismissal so that they would have to go back to the grand jury and do it. We weren't faced with a conviction.
Right, but I suggest here, every effort was made to preserve that issue. And certainly if Walzak got the benefit of the Walzak decision, Brian Grassie should be entitled to the benefit of the Walzak decision as well, even though it did not initially apply to adults. I ask you to do so now.
Okay, thank you. Mr. Thompson? morning. Good afternoon.
Afternoon, I guess, by now, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, just briefly dealing with the sufficiency and the 25P2 arguments. While there may have been evidence that supported giving the instructions on provocation and excessive force in self-defense, no fact finder, neither the judge nor the jury was required to accept that evidence and believe it. Any fact finder could have easily found that when the defendant sought the combat, invited the combat, said he was laying down the beach, that by no stretch of the imagination could the combat be deemed sufficiently sudden
Well,
that...
Mr. Thompson, would you agree that if he said, he'd been kicked out of the party, and he said, meet me at the beach in an hour, and he's at the beach, and they come running, 15 people come upon him, same argument? No sudden combat, no excessive use of force? Because an hour ago, he said, meet me an hour from now?
Right, because it's anticipated. Certainly, that's throughout the law of provocation. Excessive force and self-defense is a different analysis, Your Honor, but in terms of sudden combat or provocation, the suddenness such that it would overwhelm a reasonable person's ability for reflection or restraint is an essential, necessary part of it. If it's reasonably anticipated, if it in fact, as here, is invited, then it can't be deemed, it shouldn't be, or at least a fact finder can readily find that it's not sufficiently sudden.
Was the fight on the beach?
The fight was in the direction of the beach, toward the beach exactly where the beach is
Meet me at
relative
the
to the house.
beach?
He said, meet me in 10 minutes down the beach. He did say that.
Meet me in 10 minutes at the beach?
He had been seeking combat all night, Your Honor, so it's a,
Meet me in 10 minutes? Did he say 10 minutes?
I believe he did, Your Honor.
If this had turned out differently, and if the Mahoney's had killed Grassie, could they say that Grassie's words were reasonable provocation?
No, but the question isn't whether the defendant was, no, because the invitation to combat isn't enough by itself to be reasonable provocation, no. But...
And do you say that also kicks out the self-defense?
No, what I say in the self-defense is that what has been anticipated by the defendant and everybody else all night long has been essentially fistfights. And a jury, a fact finder, could, on the evidence here, find that the use of the knife in this situation was not justified use of deadly force because they can find, on the evidence here, that this defendant hadn't been faced with a serious threat of imminent death or serious bodily injury, Your
Well, what
Honor.
about those cases, not that you had a chance to think about them before the argument, but the cases that Mr. Anderson cites where people were beaten to death with fists and kicking? I mean...
Your Honor, the issue here is not, first of all, the issue is whether a fact finder could find that on this facts of this case, that there was no such threat inherently involved. If they could have found, I'm not saying they couldn't possibly have found something else, but it's a question for the fact finder. And there's plenty of case law that would suggest that in terms of the fist fights alone don't give justification for using deadly weapons, Your Honor.
Well, in the circumstances of this case, I mean, it's certainly conceivable that that was the only way he could defend himself. With 6 people, I forget the number of people who attacked him, at least the Mahoney brothers, put him against a fence. You could hear the fence in the tape. I mean, it's not a one-on-one. It's not a fist fight between 2 people and one guy pulls out a knife.
Your Honor, that it was conceivable is not the issue here at all. This is a question of whether, as a matter of law, no reasonable fact finder could find that there was not an imminent threat of serious bodily injury of death. And that is simply not the case. The 2 people well in front of everybody else were the 2 Mahoney brothers, the 2 people he invited down there to fight him. He had solicited that action directly. They were coming, by all indications, there was never any indication of anything more than a fist fight earlier. They were coming down there. What actually happened in the shadows, there was very little direct evidence. Nobody got a good view of there was a sound of something crashing.
Well, is he deprived of the right to self-defense because he invited them to a fight? That seems to be what you're saying.
No, what I'm saying is that a fist fight does not, as a matter of law, give rise to a serious risk of imminent death or serious bodily injury.
But the question is, did he have the right to use non-deadly force in self-defense?
No, it isn't, Your Honor, because Commonwealth versus Walker, if there was no right to use deadly force, and he did in fact use deadly force, as there's really no question that the use of the knife was use of deadly force, if he did use deadly force, then self-defense drops entirely out of the picture. That's Commonwealth versus Walker.
But self-defense as a defense to the conviction, but how about the excessive use of self-defense reducing it to manslaughter?
That is the exact point of Walker, Your Honor, with this at 443 Mass 213, where the court goes through extensive analysis to show that exactly that excessive force in self-defense drops completely out of the picture if the defendant was not entitled to use deadly force, and he did in fact use deadly force. You read the
Right. I mean, I don't know when excessive use of force in self-defense does come into the picture. I had thought it would come into the picture when you were entitled to use some force in self-defense, but not deadly force.
No,
and
Your
therefore,
Honor,
it's not a defense to the conviction, but it does reduce it to manslaughter pursuant to our instructions.
not the Walker case, Your Honor, which is not that old. It's 2005. It goes in there quite explicitly saying that the trouble with the other analysis is that there would always be excessive force in self-defense if you had even a right to punch somebody. Then if you use deadly force, then you would always have that. That has not been our law. It's never been our law. The court refused to accept that law and said that no, that deadly force is different than non-deadly force, and the entire defense drops out if there's no justification for the use of deadly force. There still is an ability to measure the degree of deadly force in the particular situation in terms of whether or not it was excessive in the particular situation, but if it's not justified, then just like the other elements of self-defense, the entire defense drops out of the picture.
Do you agree with your brother that that the evidence is undisputed that the first blow was struck by the Mahoney brothers?
No, Your Honor, it's in the shadows, it's back there. It was a confused situation with nobody ever giving a clear picture of what happened. There was an indication that somebody, inferably the defendant, was pushed against the fence. There was a sound of the fence. One or more people fell down at different points. There was the surviving Mahoney brother, I believe he says he thought his brother punched at him, but he doesn't know if he hit him. It was really left totally unclear as to what actually happened there, Your Honor.
For the purpose of the required finding issue, in the light most favorable to the Commonwealth, was there evidence that the Commonwealth could have proven beyond a reasonable doubt that the defendant didn't use every means to avoid the combat?
Yes, Your Honor. He not only left the party inviting the combat, he waited down there in the shadows, anticipating that they were coming down, so he didn't avoid it
But
because
what's
he
that
didn't leave.
moment in time, though? Obviously, he could have left before they got there, but once the confrontation takes place, is there enough evidence in the light most favorable to the Commonwealth to prove beyond a reasonable doubt that the defendant didn't use every means available to escape?
For a required finding, Your Honor, I don't believe it's appropriate to take it such a narrow, defense-oriented perspective. You can't really take it out of the overall picture and look at what happened earlier. And I'd cite the court to two cases on that. One is Rodriguez at 461 Mass 100, and the other is Andrade at 422 Mass 236. You look at what happened in the general picture and whether he had means to avoid it. He here could anticipate possible combat coming down the road, people coming after him. He stopped and waited for them to catch up to him, Your Honor. There was evidence of that. Your Honor, in terms of the judge on 25B2, he heard the evidence, he saw the witnesses, he's not supposed to sit there as an independent fact finder that sits as a second jury, and he, in his discretion, determined there was no reason to take the verdict away from the jury, and respect for our constitutionally based jury system calls for affirming that decision by him in his exercise of discretion. This is not a 33E case. A second-degree murder conviction is not a capital case. It doesn't come within 33.
The
board.
standards, you agree, the case law suggests the standards are the same.
The standard for the trial judge is largely the same as for this court. Your review of the trial judge's decision is based on whether he abused his discretion, Your Honor. And I'm suggesting there's no indication here at all that he abused his discretion.
That puts us in a very screwy world where the defendant is better off being convicted of first-degree murder in terms of the scope of our review than being convicted of second-degree murder.
Your Honor, if you have a complaint with that, perhaps you should take it up with the legislature. Your Honor, they're the ones who wrote 33E and gave the special concern for people convicted of
I didn't hear
murder
that as a
cases.
complaint. I just heard it as a statement.
Your Honor, and that's
I mean, not that Chief Justice Gants can't speak for himself, but, you know, I didn't hear it as a complaint.
just
It's
comments back and forth, Your Honor.
it's a point on the justice of the conviction. That's the point that he's making. And you're not responding.
If you want me to respond, then I will, Your Honor. If full justice is to be served, then the decision-making on whether or not a verdict should be taken away from the jury should be left almost entirely in the most just system to the trial judge, who has the opportunity to see the witnesses, to hear the testimony, to make his assessment of credibility and weight from live evidence and not from a court who reads the written transcript, Your Honor. Your Honor, in terms of the Walls Act and the proposed extension of the requirement for grand jury instructions, I would submit that the traditional principles of concerning the role and function of the grand jury lead to the conclusion that no expansion is warranted. The grand jury traditionally serves two functions, and one is whether or not there is probable cause to support the indictment, and the second is a broader, more protective function where the grand jury decides whether a particular indictment is warranted. On the first probable cause determination, that is in fact subject to judicial scrutiny, and it has traditionally been held that if probable cause is found on a not intentional and deceptive, misleading presentation, then there's no impropriety in the indictment.
Well, the issue, no one is contending, I gather, that the prosecutor offered all the evidence in this case. That's not the issue
And
here.
there's-
But the jury is faced with an indictment which says, did the defendant assault and beat Mr. Mahoney? And of course, the answer is yes, regardless of the jury's evaluation of excessive use of force, self-defense, or reasonable provocation, or sudden combat. How are they supposed to decide whether it's first degree or second degree, or whether it's manslaughter, without knowing that the standard is more than simply assault and beat?
Couple of things, Your Honors. On the second portion, the function of the jury is not so much to see whether the law is being properly applied in a particular case. It's to decide based on a community sense of justice and a community sense of fairness whether a particular indictment is warranted. Traditionally, the grand jury the court has been careful to be sure that the grand jury is not regarded as a judicial tribunal. It's not appropriate for the grand jury to be deciding guilt or innocence or relative degrees of criminal culpability.
How can it be a shield if it doesn't know the law?
It's a shield because it's a shield against the law and the prosecution and the government in general, based on the community's sense of fairness and justice, Your Honor.
But that, it just seems to me that's making Chief Justice Gant's point, right?
No.
Community sense of justice and fairness, but if you don't know that these factors that you've just heard about, justice and fairness suggest that's manslaughter, and you have no idea, how does that work?
Because they could question the law, because it's not their function to be applying the law, particularly their function is to be applying essentially the lay community values. They sit in judgment of the law as much as they sit in judgment of everything else,
But how do
Your
you
Honor.
square that with our case law that says if the grand jury asks for an instruction, they must receive it?
Because they are totally, as part of their consideration, that they, if they wanted to make that a serious factor in their...
Why is that?
Because they want it, because it's part of their decision-making process.
It's part of their
because what they want
decision-making
to do it. Because they have determined that it's appropriate. Similarly, the way they can reach out and seek further evidence on their own.
But how do they know to ask if they don't even know that that's an option?
The fact is that they're not bound by the parameters of the law. That's beyond whether or not there's PC, they're not bound by those parameters.
Told
And
that?
to suggesting
Are
what?
they told that? How do
Your
they know
Honor, I
that?
told they're in the element, they're generally instructed on the law.
Well, we never tell grand jurors when we impanel them anything about nullification.
No, you don't tell them, you ask them whether they believe an indictment is warranted. And, Your Honor, the big thing, another big thing here, especially in cases involving mitigation, is that there is, in murder and mitigation, is that there will always be probable cause for murder wherever there is probable cause for voluntary manslaughter. And it's not appropriate for this for the grand jury, which is not a judicial tribunal, for them to be deciding to choose between the normal circumstances in these cases where there very well may be probable cause both for mitigating circumstances and for manslaughter. They don't have to change.
That's fine if your only function of the grand jury is to determine if there's probable cause, but you're the one who's adding on. It's got this community sense of justice. So why doesn't that go to the fact that you need to know what are the options?
Their options are broader than that, Your Honor, is what I'm saying, is they can find whatever circumstances they like is mitigating circumstances that would warrant not returning a indictment. It's within their parameter to decide that. They're an independent body, traditionally an independent body, free from judicial scrutiny on that line. That's why we don't look at the type of evidence they consider. We're not concerned with the same kind of whether or not they go outside of the record to look at their indictments. We don't consider whether they all come in purely impartial. None of these things matter. Why? Because we don't look at the decision-making process of the grand jury. They are an independent, accusatory, investigatory body that that is largely governed by their own judgment with the sole check of being whether or not they have probable cause and on whether or not there was a fair, not deceptive and misleading presentation of
Let
the
me
evidence.
ask you a question. One of the things that I was puzzled by, and I've always not known, and certainly the Attorney General's amicus brief was very helpful, but I don't think really made this clear. What is it that gets transcribed and what doesn't get transcribed, and who makes the decision about what to transcribe at the grand jury? So we don't even know if the grand jury has asked for instructions on something.
Your Honor, I believe everything except perhaps instructions in the law are transcribed in front of the
Why is
grand
that?
jury.
Why is there an exception made? I mean, why does anything go off the record?
Yeah, I can't say, because the only inquiry is whether or not there is factual probable cause, because the rest is beyond judicial scrutiny as a matter of tradition. This is, part of that tradition is why in the past the court has recognized that it's inappropriate for the prosecution to say anything, anything to the grand jury that might influence their decision-making process,
guess my
except in response to questions on the law, and even then, only on a simple recitation of the law.
What the district attorney who's there says and doesn't say to the grand jury. I mean, I'm very puzzled at this whole notion of there being some things that happen that don't get transcribed, and I don't know who makes that decision about what not to transcribe.
I don't know exactly who made that sedition. I know it's not, I mean, my understanding is that the evidence in the questioning is always transcribed, and that's what's transcribed, which is the facts that go to whether or not
What the
there's
DA
factual
has
probable
told,
cause.
or if anything, in terms of an instruction. We don't know if the instruction given is correct or not correct in response
Again,
to.
Your Honor, traditionally, that aspect of how the grand jury arrives at its particular decision on an indictment has never been subject to judicial scrutiny, because that's part of their function as an independent accusatory and investigative body.
It's just that when we're trying to review something, we don't really know what the grand jury was and was not told.
Well, the question is whether you should be reviewing it in the first place, is what I'm suggesting here. And just like you don't look at things like the particular partiality of the jury or the grand jury, or whether the grand jury has gone outside of the scope of the record presented to them.
No,
we
for
do
example,
those
in
things.
Walzak, we've said that certain instructions would be required in certain circumstances.
You did that
Yes.
in particular with
Don't know,
juveniles.
of course, if they're being given on this notion. I mean, this is a very pedestrian question that I'm asking. It has to do with transcription, so that it's there for people to see what was and wasn't done. If we've said something has to be done and we don't know whether it was.
This case, of course, doesn't come down under Walzak, and because
No, I
the
understand it.
person
I'm
wasn't
just,
a
it's
juvenile.
what provokes the question, however.
Yeah, I don't know exactly how it's decided, or who ordered exactly what gets transcribed in the grand jury. Your Honors, determinations of relative culpability, guilt or innocence that turn on subtle distinction in the law, on issues of particular credibility, are most appropriately always done in a jury trial that is open to public scrutiny, that's open to full review and in closed questions.
Let me ask you this, if there's evidence of excessive force and self-defense, sudden combat, heat of passion, unreasonable provocation, and the district attorney presents absolutely none of that to the jury, is there a potential Commonwealth versus Mayfield or Odell motion that could be filed?
Right, Your Honor, I understand that.
So if that can happen, where is the limitation on the next step?
Where's the limitation?
So, in other words, it's not just probable cause. There's an obligation, perhaps under Odell and Mayfield, to present evidence of sudden combat, and your office did that in this particular situation, or the other mitigating factors.
Your Honor, because the rationale for that is because the grand jury should not be presented with an intentionally false or misleading overall picture of what occurred. And that goes to whether, in fact, there's been the jury has been presented with facts that could support probable cause. It goes to the review of the factual determination of probable cause, the review of how the grand jury, in fact, arrives at that decision is a horse of a different color. It's a different kind of review in its entirety, and is something that this court has, most courts in our English law system, going back to the Magna Carta, have avidly avoided going down that road, Your Honor. And it serves no practical purpose, because in virtually every one of these cases, there is in fact probable cause for the higher charge, Your Honor. And that hasn't been suggested that that's not there here, and it's not there anywhere else. When there is in fact probable cause, and the grand jury has determined for whatever reason that this case is one that wants prosecution, then the people of the Commonwealth and the Commonwealth, as the prosecution, deserve that matter to be heard in front of the trial jury, in front of a jury under the full protections given to defendants at that time, and subject to public scrutiny.
All right, thank you.